Let's find out more about this from Joseph Kotrie-Monson, criminal defence lawyer at Mary Monson's Solicitors, which is on Fleet Street. Joseph, morning to you.
Good morning, Andrew.
Good morning. How unusual is this set of circumstances surrounding the man formerly known as John Venables, because I think he has a new identity now?
Okay, well, Andrew, there are two issues here. There are the fact that the proceedings themselves are held in camera or privately, which is relatively unusual, but certainly not unheard of. And the general question that has been raised before in relation to his and other anonymity orders that exist in respect of, or when people are released having been convicted and served sentences for very serious crimes that have been so publicised and are so shocking that it puts them at risk in order for them to be released with their old identity. As far as the issue of the proceedings themselves being held privately and secretly, well, the reality is that these types of things don't cost the public a great deal of money. It's just a simple question of the court list being changed and the press being banned from those proceedings. The wider question is should those who have committed crimes and who are, when released, at real risk of danger, be afforded protection at public expense, which is what really seems to be grabbing the public's imagination every time somebody mentions John Venables.
Well, I suppose if he wasn't protected on the public purse, then he wouldn't be protected.
Absolutely, and one must, in spite of the feelings of shock and revulsion that we all feel whenever we even think about that terrible case, even these 20 or so years later, one must separate the crime from the situation of the individual and their safety. On their release in 2001, Venables and Thompson were granted anonymity as a result of this High Court order. And despite that, the number of vigilante groups both trying to find them, disclose their identities, and even threatening with serious harm has not diminished. In fact, people and organisations have breached those anonymity orders, trying to make public who they are, where they are, and to face separate criminal prosecution themselves. So, there's arguably a need for those orders.
And the actual charge that Venables is facing, Joseph?
Well, possession and distribution of indecent images. They say making, but making does not mean carrying out the photographs. The photographs, it can simply mean viewing on one's computer or the act of saving something on one's computer. He's been convicted of it before. We can't comment on the details of it. I don't know for a minute if the evidence stacks up in that case against him. Is it worth saying that as far as sexual offence is concerned, it's at the lower end of the spectrum? I think that's probably unhelpful given the history and given the fact that any sexual offences that are covered by the criminal catalogue of legislation are inherently serious. And
just finally, Joseph Kotrie-Monson, what about John Worboys, the black cab rapist, as he is so called? Over 100 victims, it would appear. The police absolutely incensed by the fact that Baroness Scotland didn't refer his 8-year IPP sentence to the appeal court on the grounds that it was too lenient all those years ago. What's your view?
Well, I think the police here are engaging in a little bit of egg-on-your-face diversion here, and this is something we can much more keenly talk about, that I've got a much stronger opinion on. First of all, if there are 100 victims, why wasn't he subsequently charged? We've seen in all these high-profile paedophile cases that once more victims come forward, the police and the CPS work to do a second prosecution to make sure that these people are out of action for good. For the police to then, or the CPS then, to start talking about, well, this isn't our fault, this is either the probation service, this is the judge, this is the Attorney General, I think that is a complete smokescreen. The reality is there's one of two interpretations in that case. Either there simply wasn't the evidence, in which case we can't call him a 100-time rapist, or That's not how our society works, whether you like it or not. Or it's the police or the CPS who should have charged and didn't. The amount of misinformation about this. And, the reality is, of course, we're talking about somebody who committed, I understand, offences against 9 individuals, and that sentence might seem inordinately low. We don't know, of course. We're making presumptions about the level of rehabilitation before his eventual release, because his release wasn't apparently on the first application into his indeterminate sentence. But to be talking about, well, this person's committed 100 crimes and he's getting out, therefore let's attack the justice system. I'm afraid it's not the justice system at fault here.
All right. Thank you very much indeed, Joseph Kotrie-Monson.